Good afternoon, everybody. Welcome. My name is Caroline Allegre, and I'm the Advocacy Program Manager for People with Disabilities Foundation, and I'm very pleased to be the MC for today's seminar. This is the 15th three-hour seminar in a series of educational seminars ranging in topics from multiculturalism to employment and post-secondary education in the psychiatric and/or developmental disabled community. People with Disabilities Foundation was founded 15 years ago with a mission of total integration of people with mental and/or developmental impairments into the whole of society. PWDF is a Section 501c3 public charity based in San Francisco. Our primary focus is on psychiatric and developmental disabilities. In addition to seminars, we produce training videos for human resource directors and vocational rehabilitation counselors, and CDs on subjects such as Social Security work incentive programs and housing. Our other program component is hands-on advocacy in 8 counties for representation in Social Security cases and education, employment, healthcare, and housing, as these areas relate to individuals' mental disabilities. Our founder and legal director, Stephen Bruce, has spent over 25 years as an advocate for those with disabilities. He is a member of the California, Florida, and the District of Columbia bars, and admitted to practice before the United States Supreme Court. Like the Americans with Disabilities Act and Section 504 of the Rehabilitation Act of 1973, the Fair Housing Act amendments of 1988 requires that people with disabilities have equal opportunities to housing, with or without reasonable accommodations. Under the law, people with disabilities have the same rights to participate and/or enjoy programs and activities regarding housing, employment, education, and other activities. This includes the right to live in the most integrated setting.
Hi, everybody. I'm very happy, first of all, to introduce our representatives from the State of California Department of Fair Employment and Housing, Colleen Janatpour and Lillian Miwa-Maher, who are going to talk about the Fair Housing Law overview and enforcement process and reasonable accommodations.
Thank you. Hi, I'm Colleen Janatpour with the State of California Department of Fair Employment and Housing. The first part of our presentation is just going to explain some of the laws that we handle under the Fair Employment and Housing Act. You want to click it when? That's just our number and website if you feel that you've been discriminated against. So the Department of Fair Employment and Housing, we receive and we investigate and attempt to mediate and conciliate discrimination complaints that have been filed under numerous protected bases under the Fair Employment and Housing Act. The laws that we enforce are the Fair Employment and Housing Act, the Unruh Civil Rights Act, the RALPH, which is hate crimes, and the Disability Persons Act. The protected bases under the Fair Employment and Housing Act are disability, race, color, familial status, which includes children under the age of 18, women who are pregnant, marital status, being single or married, source of income, which could include disability payments, gender identity, gender expression, gender information, medical condition, which would include cancer, ancestry, national origin, age. There's no limitation on age, religion, sex, gender, sexual orientation. Source of income's on there twice. Some of our statistics for 2014 show that the number one, or the few bases that we receive most complaints on is disability and race, color, and familial status, but disability is the number one complaints that we receive and we investigate. And some of the common violations are unlawful inquiries asking if a person has a disability or asking what their disability is, refusal to rent or sell, harassment, retaliation, which includes eviction. So when a person makes a reasonable accommodation request and the landlord turns around and retaliates against them by serving them with an eviction notice. Denial of a reasonable accommodations or modifications, and overly restrictive rules, families with children again. I don't know if I need to read that part. So unlawful inquiries, as I said, is to make an inquiry concerning a protected characteristic of a person, asking, once again, what is your disability? Or to advertise a rental or sale of a housing accommodation which indicates a preference or limitation based on a characteristic protected under the Fair Employment and Housing Act, which are those protected bases that I listed earlier. Harassment. So it's unlawful for a landlord or a housing provider to harass a person because an individual is a member of a protected group. If a tenant is harassed by other tenants because of a protected group and the landlord is aware of the harassment, they have an obligation to try to intervene and stop the harassment. If they don't, they can be financially liable for the harassment. For sexual harassment. I lost my place on my... Sorry. So, once again, it's unlawful for a housing provider to subject a person to sexual harassment or to inquire a favor for sex in place of a favor. It's called quid pro quo, so a favor for a favor. So if a landlord says, I'll pay part of your rent or allow you not to pay a portion of your rent if you have sex with me, or if you go out to dinner with me, or if you go on vacation with me, or something like that, it's unlawful for the landlord to do that. An unwelcome, unwanted, verbal, physical, or visual behavior of a sexual nature could include, but is not limited to, sexual advances, derogatory sexual comments, leering, touching, including rape. So familial status is for, once again, just families under children, families that have children, minors under the age of 18. So it's refusal, so a landlord cannot refuse to rent to a person because they have minors or children under the age of 18. Make overly restrictive rules, such as children aren't allowed to play outside, not allowed to ride bikes, skateboards. It's unlawful for a landlord to do that, to put these overly restrictive rules on families with children, or to segregate families with children, put them in a different area of the complex because adults don't want to deal with children. And then we have...
Excuse me, Colleen,
Yes.
just one point of clarification. Like sexual harassment, disability harassment is also illegal, and in terms of the affirmative obligation of the housing provider to not permit ongoing sexual harassment, the same is true for disability harassment, correct?
Right.
Okay.
Right. And that's like one of the topics I do want to elaborate on, because we've had, or at least I've had, many cases where a landlord has taken advantage of a person because they're disabled. And the person doesn't realize they're being taken advantage of. And so, yeah, it's unlawful for the landlord to sexually harass someone because of their disability.
If it comes to something that doesn't arise to
It has
that
to-
level, but making fun of a co-tenant who's disabled or teenagers, for example, aggressively bullying and making fun of disabled people, the
Yeah, that can
housing
also
provider has an affirmative obligation
To prevent.
that from continuing?
Exactly.
Thank you.
Yes, they do. As long as the housing provider is aware, I don't know if it necessarily has to be reported, as long as they're aware of it, then they do have an obligation to prevent or to help prevent the ongoing harassment,
Thank you.
okay?
Question?
Yes.
Yes.
What if you have a situation where you have a tenant
Let me get the microphone.
verbally abuse other tenants, and this person being very aggressive, very abusive,
Yeah.
verbally, and the landlord tried to look the other way and not deal with it.
So that's where it can be, where the landlord could get in trouble with the Department of Fair Employment and Housing. If,
Excuse me, I'm sorry, would you mind just repeating that question into the microphone?
My question was that, provided you have verbally abusive tenants who abuses other tenants and sometimes staff, and when this was reported to management, to property management, and but the landlord or the property manager was also maybe intimidated and try to look the other way and not deal with it. That was my question.
well, the landlord has an obligation, if they're aware, and as long as the harassment falls under one of the protected bases under the Fair Employment and Housing Act, they have an obligation to stop the harassment. They can't just turn, the other way and just ignore it. They do have an obligation. And, if one of the tenants is harassing the other tenant and they have some sort of disability, and they make an accommodation, we'll get more into that, then that may change the situation. Okay, but the landlord does have an obligation.
And also, I think it would be helpful in that kind of situation to document, to, make it clear that you're reporting this to the landlord or the manager, and that, make the connection that if you think it's harassment, not just because this person is, mean and verbally abusing everybody, but if it's connected to one of the protected bases, and then, log it, when did you notify the landlord and what happened, what was their response? So that way, later on, it might not be he said, she said, I didn't know about it. So I think it's important to document those.
And I always tell the tenants to submit it in writing, even mail it if possible, certified, and that way they have a receipt to show that the landlord received their complaint. So before we go on to disability, I did want to share one more thing, in that discrimination does not include either of the following: refusal to rent or lease a portion of an owner-occupied single-family house to a person as a roomer or a boarder within the household, provided no more than one roomer or boarder lives within the household and the owner compiles anyways. So if it's an owner-occupied unit, one single-family home, and if the landlord discriminates against you, unfortunately, you wouldn't be able to file a complaint with our agency. The other one is where sharing of living areas in a single unit, a single dwelling, and unit is involved in the use of words stating or tending to imply that the housing is being advertised, is available only for persons of a certain sex. So, a female renting out a single unit like that can say that they prefer another female, because they're sharing living areas, common areas of the home.
But when in doubt, then please call us.
Definitely.
And talk with our intake consultants, and then we can, talk about it. So don't just assume, that if there's any question, please err on the side of calling
Yeah,
us.
call us, because we do have, it's called an officer of the day, just to answer questions. So if you're not sure, just call us, and one of us would be able to answer the question
Okay,
before going online.
and I'm being told we have 5 minutes, so to get into disability and reasonable accommodation, so I do want to point out that here we're talking about the state. We have a broader definition of disability than under federal. So for us, disability is a physical or mental impairment that limits one or more of a person's major life activities. So we don't require a substantial impairment or substantial limitation. It just needs to be a limit. So that's one important key thing to understand for us. So, and we will be focusing just on the state. So one of the things that we do, which Colleen mentioned before, is investigate denial of reasonable accommodation allegations. So, for example, a common one is a request, say, to have an emotional support animal in a place where there is a no pet policy, or having a live-in aid for someone with a disability. And we also investigate allegations that there is a denial of reasonable modification, so that would be more of a structural change. And then, see, I'm gonna... Sorry. So that's really one of our most common ones. So it's some examples for our complainants with psychiatric or developmental disabilities are making those requests that have to do with communication. Say if the tenant cannot communicate with the landlord directly or wants to change that type of communication, have somebody else be the spokesperson, or have things just in writing if it's not an emergency. Those are some common requests that we look at. And go ahead.
Another one is like someone who, let's say, is bipolar and has an episode. And as an accommodation, they ask the landlord to give them another chance, that they'll, go see a doctor, or even like schizophrenia, if they'll go, get on medication. The landlord has an obligation to engage in an interactive process, which means, talking it out with you and coming up with alternatives with the person that's disabled that's making the accommodation request.
And I think that's a key, I'm sorry, but I think that's one of the key things, is that interactive process, that it would be helpful to, also, I'm a big fan of just writing everything down, document when you make those requests, if they are responding, if there's any, if there is that interactive process going on.
I always suggest that you get a note from someone that's familiar with your disability, because under the law, the landlord does have a right to ask that you provide documentation to support your accommodation request.
Excuse me.
I have
I just had a quick...
Just a general question about HUD versus the State Department of Fair Employment and Housing. if there is some urgency to the situation, let's say there's a high risk of someone becoming homeless, mentally ill, let's say that someone has decompensated into a full-blown psychotic state, or is in the hospital, maybe just up here at Langley Porter or somewhere for a couple of weeks, where is the best place to go to get relief more expeditiously? Would it be through the Superior Court, through HUD, through an administrative law judge, or through your agency, if we're talking about irreparable harm or some urgency involved?
So it sounds like you're asking, so which one would be the fastest, get the
Right.
fastest response?
Expedite that.
So, well, we can only speak for, for the department. We will handle things, as quickly as we can. I think one important thing to do, at the very beginning is indicate that this is an urgent matter, explain that there's potential for homelessness or, at risk for homelessness, and then, exactly what the reason is to need that, that
Do
to
you
be
have a fast-track system under those facts? Assuming what you
We
just
have
said.
priority intake, so they should, indicate, what the urgency is, and we'll try to get to that. And, we can't speak for HUD, but it may actually cause some delay if there is dual, if they file with us, they file with HUD, we'll eventually try to work it out to clear up which one we're investigating. But I think just file it as soon as possible and indicate what the urgency is.
Do you have any kind of memo of understanding with with HUD in terms of, in other words, an employment, they can file with the EOC?
We do.
And they will send
We do.
a copy? Oh, you do?
We
Could
do,
you tell
yeah.
us what the agreement
So
is
our
with
cases
HUD?
are dual file with HUD if it meets their guidelines. So, and if you go to HUD most likely would turn the case over to us for investigation.
Oh, okay.
Right. So,
Thanks.
we do. Were there any questions?
Yes, I wanted to know about the grab bars, things like that. Does the disabled person pay for that, and the landlord has to let them put it in, or does the landlord have to pay for
I'm sorry, I don't see
changes?
who's talking. Where?
Right
Oh, I
here. I'm
apologize.
sorry.
I'm sorry. For modification?
Yes.
Usually, it's the tenant that pays for it. However, there is some circumstances where the landlord would have to pay for it if there's federal funds involved. But you can always, check with HUD on that, or even with us,
And then I thought the other issue that you just brought up, Stephen, would be a TRO might be the best thing to do, a temporary
Oh, yeah,
restraining order
probably.
to stop them from kicking you out, I would think. I don't know.
Yeah, we've had many tenants do that. Yes,
Is there other exceptions to familial status being a protected class?
Can you repeat that question in the
any exceptions to familial status being a protected class?
Yes, when I rented from nonprofit in 94, and then my son was born in 96, and they would not put him on the lease, and then they made me fill out overnight slips for a breastfeeding newborn.
I'm so sorry. Maybe we can
Stand-
answer that question for you during break time, because that's more of a specific question. So I'll talk with you
To
at,
do with McKinney Federal funding. So that's what I'm asking you, are there exceptions to familial status? Because I was discriminated against as a mother of a newborn. After I had a place, they said it's federally funded.
okay, and I will, I'll discuss that with you during break, okay? We only have a minute up, and then the next person has to come on, so I'm sorry, and,
So the takeaway is,
Yeah.
please contact us if there's any questions.
So just really quickly, so we also have the hate violence crimes, and that's if you believe that you are being targeted, if there's a act of violence towards you because of a protected basis. Once you identify who that person is, then you can file a complaint with us under the Ralph Act.
Or also for a threat of violence.
Right, threat to violence. Then there's a Unruh Civil Rights Act, and this is basically if you're discriminated against by any businesses in California and and you live in California, or you're a resident of California, of this state, then you can file a complaint. One of the big ones is businesses not allowing someone in when they have a service animal. So that's, you can file a complaint with us. Companion animal, service animal are the same under the state. It's a reasonable accommodation based on a disability.
She's coming. She's bringing it.
And she was asking if there's a difference between service animal and emotional support animal, and under the state, it's the same. It's a reasonable accommodation request based on a disability.
Including during places of
Housing.
public accommodation, including what we normally think of as Title III entities under the UNRRA Act? Because that's where the big confusion is, and we have part of the California Agricultural Code saying that only service animals, or the Department of Public Health, California Health Department, saying that only service animals are allowed in establishments that have to do with food, and yet we have UNRRA now that says a person cannot be discriminated against in a public establishment, including a restaurant or whatever, if they have an emotional support or a service animal. So it's very confusing, and for us trying to help clients and advocate, there is no clarity between two different state departments.
Let me say this, which may help clarify that in 2011, Department of Justice revised the rules on service animals, and housing is an exception. The HUD and the state agency does permit emotional support animals. It does not have to be a dog or miniature horse, which means pony, who have a specific tasks to which they're trained, like to remind someone to take medication, or a student in elementary school to stay the full day. That is not required under the Fair Housing Amendments of 1988 in HUD or under the California Department of Employment and Housing. So emotional support animals, not just service animals, are reasonable accommodations in housing as opposed to public accommodations. Right. Yeah, public accommodations, including schools, emotional support animals are not permitted. The animal has to be trained to perform a specific task, whereas the definition in housing can be emotional support. They do not have to be trained or certified as such, and they are permitted. So it's a carve-out in housing.
Right, but my understanding, based on what Pauline was just saying, under the UNRRA Act, there is no distinction between a service or a support animal. Is that correct? Am I hearing you correctly? In housing.
In housing.
In housing.
Not the public accommodation.
Correct.
Public accommodations are different.
Okay, thank you.
Okay. So we don't have time to go over the housing damages, but for filing a complaint, you can either go onto our website or you can give us a call at that 800 number there.